For decades, English family law was defined by conflict. To end a marriage, the law required one person to prove the other was to blame. But that historical friction was shattered in 2021. The Dissolution and Separation Act 2020 removed the requirement to prove fault. It eliminated the 5 facts that practitioners previously relied on, such as adultery or unreasonable behavior. Instead, the law now requires a single document to dissolve a relationship, a formal statement that the marriage or civil partnership has irretrievably broken down. This legislative change moved divorce away from the courtroom battleground and into a standardized administrative process. Navigating this administrative transition is the baseline for current family practitioners. To maintain this neutral environment, the statute updated the specific legal language used in every case. The person starting the proceedings is no longer a petitioner. In all modern filings, they are the applicant. The term decree nisi has been retired. The court's initial confirmation is now called a conditional order, and the final decree that dissolves the union, formerly the decree absolute, is now the final order. Adopting this neutral lexicon allows a practitioner to frame the process correctly for their client and the court. This timeline follows the mandatory statutory path. We begin at year 0, the date the marriage or civil partnership was officially formed. Under Section 3 of the Matrimonial Causes Act 1973, there is an absolute bar on divorce applications during the first 12 months. This waiting period is a matter of public policy, intended to prevent couples from making hasty legal decisions immediately following their union. Once that first year passes, the application stage begins. Practitioners now initiate this process primarily through the digital portal. The 2020 Act provides 2 distinct paths for this filing, a sole application or a joint application. A sole application involves one applicant and one respondent. In a joint application, both parties act together as applicant 1 and applicant 2. Crossing the 1-year mark opens the procedural gateway, but the structure of the case is determined by whether the parties apply together or alone. This logic diagram shows how the current law filters disputes. A respondent can no longer defend a divorce by arguing about why the relationship failed. An application can only be disputed on narrow jurisdictional grounds, like challenging the marriage's validity. Once the application is issued, the timeline triggers a mandatory 20-week waiting period. The statute requires this 20-week gap to function as a period of reflection for both parties. For practitioners, this window is when parallel negotiations regarding financial remedies and child arrangements are typically resolved. By removing the ability to argue over fault, the law focuses the parties' attention on dispute resolution during this 5-month window. When the 20 weeks expire, the parties reach the next major milestone, the conditional order. This order is the court's formal confirmation that the applicant has met all the statutory requirements for the divorce to proceed. It is important to note that the conditional order does not end the marriage. The legal bond between the parties remains intact at this stage. The court does not issue this order automatically. In a sole application, the applicant must submit a specific request to move the case forward. In joint applications, either party can start the request, which triggers a 14-day window for the other party to complete their portion of the filing. If cooperation breaks down in a joint case, the party who initiated the request can switch the track to a sole application. The conditional order serves as the halfway mark, confirming the grounds for divorce while the final severance remains pending. A second mandatory waiting period follows the conditional order. The parties wait a minimum of 6 weeks and 1 day. After this final wait, the parties apply for the final order, the legal decree that dissolves the relationship. An applicant has exactly 12 months from the date of the conditional order to submit this final application in time. In a sole application, if the applicant misses that 12-month deadline, the respondent can apply for the final order themselves after a further 3-month delay. Under Section 10 of the Matrimonial Causes Act, a respondent can ask the court to hold the final order until fair financial provision is established. Once issued, the final order carries immediate legal weight. Provisions and wills lapse automatically, and both parties lose their rights to inherit under intestacy rules. The final order marks the legal conclusion of the relationship, terminating the statutory timeline and altering the parties' status permanently. For clients who object to divorce on religious or personal grounds, there is a distinct alternative: judicial separation. While the requirements for judicial separation are similar to divorce, the timeline follows a different set of rules. First, the 1-year absolute bar does not apply here. A petition for judicial separation can be filed immediately after the marriage begins. Second, the process stops before the final order. It terminates the duty to cohabit, but the marriage itself is never legally dissolved. This framework provides the financial and protective remedies of separation without the finality of a standard divorce. The DDSA 2020 successfully established a streamlined administrative system that now operates entirely without the friction of adversarial litigation. This shift moved family practice away from investigating past behavior and toward managing the procedural realities of separation. Guiding a client effectively through this process requires strict adherence to the 20-week and 6-week statutory waiting periods. Precision with the updated lexicon, applicant, conditional order, and final order is a requirement for the modern practitioner. Mastering this procedural architecture is the baseline for advising any client navigating the dissolution of their legal relationship.